So, dear participants, please take your places and we will begin the meeting and the discussion. So, good afternoon, everyone. So, to follow up the topic we started with, we'll talk about individual reparations, stages of providing, and to moderate this meeting, Madam Clara Sandoval, who will be presenting Global Fund of Helping the Survivors. And I'm head of the JurFem think tank. And our speakers for this session, thanks to whom we have the honor and pleasure to discuss all these topics. So let me remind us all shortly who's with us. Marina Bardina is joining us. We'll be able to talk to her. She's an MP, head of the temporary commission at the parliament to investigate sexual violence acts committed by Russian troops in Ukraine. Vasil Luk, head of the national service. Yulia Dvornichenko, Sama Ukraine. Fender Duribabin, the representative of Global Fund of Helping the Survivors. So Olga Chuyeva, especially from UN Fund in responding to sexual violence. And we have the pleasure of greeting online Natalia Kubish, a legal specialist of redress. So please make yourselves comfortable, be active listeners, and ask questions to try and find answers to them. So primarily what we start with, to follow up on what we were discussing a lot today, is creation of legal framework and mechanism of reparation. Because after the 2 years of large-scale warfare and about 10 years of war that Russia wages against us, there's this question, how to help all the survivors, regardless of whether pre-trial investigation on which stage, criminal investigation on which stage, and whether the persons actually can receive a due complex assistance, and to what extent the state is ready to provide these services.
Okay. I just would like to frame this conversation from an international perspective and just say, yes, a framework and a policy are essential to move protection for survivors of conflict-related sexual violence forward. Internationally, we have more than 20 years of relevant experience coming from countries as varied as Peru, Kosovo, Colombia, Iraq, and I can continue to mention them. And a few lessons have come and are on the table that we can learn from, that can inform important decisions here in Ukraine. And I just want to say a few. In terms of frameworks, what we've seen is there are countries where you have had a variety of laws being enacted to protect different groups of people, and that is the case, for example, of Chile or Argentina. And we even have countries like Iraq that have come up with a specific law, the Yazidi Survivors Law, in order to protect survivors of conflict-related sexual violence who were victimized during the genocide. There are other countries that have opted for more comprehensive legal frameworks where they include all victims, and that's, for example, the case of my own country, Colombia, with the Victims and Land Restitution Law. It doesn't matter what the format is, if it is one law or for its various laws. This is also something that responds to opportunity and to the disposition of the state in terms of how to address this. But a few lessons have come up, and I just want to quickly mention some of them. What we know is that these frameworks need to be survivor-centered. need to include participation of victims, need to include protection mechanisms that would allow survivors of conflict-related sexual violence to come forward. They will also need to be focused not only on the forms of reparation that are given to victims, so not only the result, but they are about the process. How do we create and put in place a process that is experienced by the victim as truly reparatory? And the fourth element, and I think this speaks particularly to the Ukrainian case, is the need to have complementary systems where all remedies, national and international, speak to each other. We will not progress reparation for survivors of conflict-related sexual violence or accountability if we have separate remedies that don't talk to each other, that don't try to simplify the experience of survivors. Just with one example, if a victim comes here today in Ukraine and goes to one of the many remedies that are under discussion here, but then again, in order to claim for the reparation, needs to go yet to another system, start the whole registration process again, we are not really being survivor-centered. We really need to ensure that the variety of legislation drafts that are currently in Parliament speak to each other, coordinate with each other, and make the process simple and lean so that survivors can have actually access to reparation. So I just wanted to say that. And now with this, we start with our first question, Kateryna.
Так, дякую. І сьогодні ми вже про це говорили.
Thank you. Yes, we mentioned two legal initiatives in particular that are being registered in the Parliament at the moment. But as of now it's 2024, March 2024. So as of now, we don't have officially voted law on reparation mechanism. So we're talking about it. It's an important work in this regard, but still, the question that I propose to start with, which is very important, is as of now, with all these legal initiatives that exist, in your experience, since we represent experiences from governmental and civil society, so what absolutely in the existing draft law on reparations, what has to be included there, so that all the needs of survivors from sexual-related violence would be accounted for and remedied. So I'd like to pass the floor to Julia first, and let's begin. Greetings, everyone. I'm a bit excited in terms of stage fright, so sorry. What specifically has to be in the law? What is important? Right. What does the state provide so that the rights and the needs of survivors are met? You know, I was preparing what to say, but now I'm a bit nervous, so it kind of, just from my experience, I can share what, from my experience. I was in captivity for more than 2 years. I was in captivity, and it's a separate story. I also have children. When I got into Russian captivity, my both sons were underage. Now, thanks God that they are with me, but they are in some kind of shadow. That's unfortunately how it is. You know, there are funds that are helping, but in order for them to be able to do that, I had to go through so many steps. I just don't want any other woman or mother who faced this kind of situation like me to have to go through these steps. I would want our government, our laws, really be children-centric and human-centric. The children are codependent on this situation, sorry, but that's the way it is. I'm a mother who survived the sexual violence and abuse. My children automatically are affected and traumatized by this. They are traumatized, and my children, not only my children, they need psychologists, they need assistance, they need help. We do have psychologists, but it's psychologists for a certain amount of time. After that time is over, it's no longer free assistance. It is paid assistance, so it's not pro bono, and we cannot afford it. You know, it's women and children and men, anyone who survived sexual violence should be provided with these services for free. Yeah, and people who accompany these people often don't know how to help them, and they also require assistance from the state in this. So, Maria, if you can share your experience about the actual legal initiatives, what are we talking about? Thank you, Kateryna. Good afternoon. Sorry for being a bit late. We were talking just behind the scenes here with the civil rights activists. How do we work on the second draft law and the second reading? And you know, drafting a law, it is difficult. It's hard work because you need expert support. You need people who did have this experience to account for all the nuances, and to have not just a law that will push the survivors to another 9 gates of hell to go through offices and agencies, etc., but to write an actual working law, understandable, clear, and human-centric, survivor-centric. But there's another element, advocacy in the parliament, and going through all the approvals with all the stakeholders. What I face now is that a lot of people and agencies, just like in law enforcement, they take war crimes as a crime that has to be proven through court, litigation. The court determines the remedy, and only then the assistance comes. We discuss a lot about it, and we're going to talk about it much more, because this is the mindset that has to change. The mindset of people, the governmental people. We talk about sensitivity. We ask them, please listen, please hear those men and children and women who had this experience, who were sexually violated by occupants, by the aggressors. And people are not ready to wait for the court to decide. And courts are not as fast as we want them, but the assistance cannot wait for months and years. Psychological, social, this intermediary reparation that a person can be eligible to. So we're convinced, and we work towards Russia paying for the crimes they committed. But we have to start doing already the active support. Just last week, Profile Committee, Main Committee on Human Rights, did look into the draft law. It recommended to the Parliament to take it for foundation. But again, this mindset, that people can get assistance from state without a court ruling, without going through different stages of talking to law enforcement, but can actually get assistance with talking to trusted people or going through paperwork if they don't want to, re-trigger themselves through talking about it again and again. We also have to help them with that. We created a trusted circle of people in the committee that should decide whether the person that came to them actually survived sexual violence. It will be law enforcement and civil rights activists, because they enjoy better trust to themselves than public institutions, because a lot of survivors already cooperate and are getting help from civil society. So on this stage, when we realize what kind of mechanism we need, we see it working in other countries, in Croatia and Kosovo. So it's basically the same mechanism, but more adapted to Ukrainian context. And especially when we have international partners who are ready to help, ready to grant financial help so that we would be capable of paying the compensation. So you have to take and do it. You know, it's important to communicate that it's not necessary to wait for court ruling if we talk about CRSV. And as Julia said about family members, so in our draft law, they also affected people, and they are also survivors, because we want to help, and we've heard the survivors talk, and we want to understand and write it in the law properly so that you have a really effective mechanism that is capable of helping. So the next step is passing the law by the parliament, and then the second stage is working with our team on this draft law. So I hope we will pass this law till the next meeting, because it's been a lot of conferences, there's been a lot of discussions, and we say that it's important, and other than talking, we have to already deliver results. Thank you. Dear colleagues, you know, I also join in saying that the first step now is to pass the law. After that, there will be cabinet of ministers, there will be the committee's work, etc. And also, it's important here to have both public and the state. But also, I see that we have to work more complex, because among the survivors, what they need first is social services and medical assistance. So when we talk about changes, the law on social services is just as we are helping the survivors of human trafficking. They receive like free legal assistance, other social services. So design a set of social services based on the structures that are in the policy. It can be the entry point for all the survivors. We also see that we attach the status of survivors of human trafficking, but through so part of them are also CSRV survivors. So you know, the mechanism of providing them remedy with no court litigation, it works, and we should not deny our citizens the right to have the same procedure, expedited procedure, without waiting for the court to rule, and then this ruling should be enforced, etc., etc. So we, in our turn, we see, since our objective is to run the checks of maintaining survivors' rights on all the stages, so we see that there is a need in training. People need to get training, and so we trained all of our ex-employees working with CSRV survivors. But when we go to different other levels, we see people still far from properly understanding this. So we're doing trainings, and this is very important, because the people who survivors come to, they should be educated. It's their attitude towards the survivors that will determine whether the state policy will work or not. If the survivors will not forget about public services and still go to civil society. Okay, thank you. Civil society and interaction with the state. Fedor? Yes. Indeed, the urgent need is to have laws actually working with each other, not creating hindrances for other laws. Because if the Ministry of Social Policy passes the law on the register, it has to be attached to International Register of Harm and Damages Done. And there was a question, what's the most important in this draft law? I would say most important is to hear the opinion of survivors themselves. We have a lot of categories, different patterns of survivor cumulative effect. The people who survived captivity, they lost their property, they lost lives of loved ones. So these are all people who have a complex damages from armed aggression. So we don't have any definition of what CSRV in our law. It is in the law on free legal assistance, but there has to be determined what are the rights of these people and what assistance we need to provide them. So it needs to be a framework, but a more general framework. Because otherwise we can create a complex assistance, but it can be too complex. It's too complex to measure and too resource hungry. Second part of it that I see is that each provision of this law should be aimed at restoring the rights. Even if the people who are not legal savvy, who are not used to reading legal text, it should be clear, it should be understandable, written for them. So that whenever they come for legal assistance, they can refer to this law understanding what it says, so that it encourages them to get that help. That's why we're creating this pilot system, pilot project of reparations, to make it, as you know, in Protestant countries there's this principle: never try to provide assistance to people who didn't ask for assistance. But if they did ask for assistance, you have to do everything possible to actually help. So the draft law on initiatives it should aim to creation of the system that works. If the survivor comes 10 years after, 20 years after, it is capable of providing high-quality, holistic assistance. Thank you. So I would support what Fedor said, and to say that the programs they should answer both urgent and long-term needs of the survivor. So at each stage, as we've heard, we have to understand what specific assistance the survivor needs at this stage. As Julia says, we have to engage. We have to help restore this right to the family members. We have a great example when we piloted the rehabilitation recovery for women in Carpathian. Julia participated, and we also asked the son of Julia to join this 2-week program in Transcarpathia. And it included psychoeducation, medical examination, self-help practices, self-stabilizers, cognitive recovery and rehabilitation. So 13 members of Sama Ukraine participated in that program back then. So the first task was to provide recovery. The second, to listen to them, for them to be heard. So in 2 weeks of pilot program, we realized we have to work some more on this program. So it's important. That's why it's important to engage the survivors to this initiative that helps them restore their rights. So Natalia is online.
Well, apologies, I had some issues with translations. I missed a bit at the beginning, but I caught up. So I think, of course, there's a multitude of criteria that should be considered when setting up a reparation mechanism for victims of conflict-related sexual violence in Ukraine. But today I will address 4. So an initial challenge in designing any reparation program is, of course, determining who is eligible for the scheme. In essence, this means defining the victim group. Reparation programs risk excluding groups from receiving benefits if the eligibility criteria are narrowly defined. They also must not discriminate based on the survivor's race, sexual orientation, gender identity, socioeconomic position, political belief, or any other protected criteria. There are still many categories of survivors who may not always be recognized as such, including, for example, soldiers or individuals who may have simultaneously collaborated with Russia and have been victims. Other victim categories have also received less attention, such as those who have suffered violations prior to full-scale invasion of Ukraine, are disabled, are over 60-year-olds, and those who have suffered domestic violence at the hands of veterans suffering themselves with symptoms of post-traumatic stress. Therefore, to ensure that the reparation program is inclusive, effective, and adequately responds to the needs and priorities of everyone's affected, victim participation at the outset is critical. Such participation should be transparent and can take many forms, from direct engagement, collective responsibility, collective representation, or regular correspondence. Second, reparation, of course, must be accessible. This means that survivors must have access to and are aware of the mechanisms available. Authorities must eliminate any legal, cultural, economic, geographic, or other obstacles that can prevent survivors from accessing reparations. Application forms should be simple and victim-friendly, be available in paper and online, and also in different languages. Additional measures may also be necessary to reach those who are most marginalized, including those who are displaced, who live in rural areas, migrants, and children. Some initiatives in the context of Ukraine are already in place. For example, the Ukrainian government has launched an online information and relief center. However, consultation with victims of CRSV in Ukraine also demonstrate that some victims are still not sufficiently informed as to which reparation initiatives are available and how they could apply. Third, reparation measures must be appropriate and proportionate to the gravity and circumstances of the violations. They need to respond to the individual facts of each case, the harm suffered, whether that's physical, psychological, economic, or social, and of course, respond to the victim's needs. A key consideration here is whether the reparations will be delivered on an individual or collective basis. While individual reparations respond to the harm suffered by individual persons, collective reparations may be more privileged, where it's difficult to draw a clear line between victims and non-victims, and where there's limited capacity to implement individual reparations. Questions, of course, also remain over whether initiatives that emphasize compensation correspond to the requirements of CRSV survivors, who may prioritize reparations in the form of rehabilitation instead of individual financial reparations. And now, fourth and finally, reparations mechanisms must be adequately resourced to ensure reparations can be delivered comprehensively and without undue delay. This requires, at the domestic level, a dedicated budget line to sustainably fund reparations. Where available funds are insufficient, other states in the international community should also step in to provide voluntary donations and fill the reparations gap. Now I stop here with these three factors, but I'm happy to answer any questions during the Q&A.
Thank you.
Now we are going to go to the second question, and just to pick up on one of the comments you made, Ms. Bardina, that we need to move to action, because there is a lot of support but no action. That's my question to all of you. How do we ensure that the framework, and here we have two laws and the International Registry of Damages, etc., really moves forward and we get implementation from the policy? What can you do from your respective roles, but what could others do to ensure this happens? You know, it's unique. This is really I have never come across a country like in Ukraine that is ready to address in real time conflict-related sexual violence. And you have the actors in this room and you have the opportunities here. So how do we move that forward? Ms. Bardina.
Дякую.
Thank you. You know, I'd like to say that assistance, as well as from international community, is communication, both public and donor assistance. It is extremely important. And the movement toward passing these laws, towards having more precise steps in legislative field, that's our homework, rather. That's our internal work that nobody but we have to do. And the communication with people who will vote in favor of a certain decision, it's important. We need to communicate those people from everywhere we can. And I think we will pass the decision quickly in the first reading, but we also have to agree on the final version of the law, how it's supposed to look when the whole law will be voted in the parliament. So it's important for us to pass the final steps on the final version of this draft law. And I think this is more about expert work, which is basically a back office of this draft law. Well, I would say we have to balance different components. First is when the legal framework will be passed, it has to provide proper interaction and coordination of all the stakeholders that are involved in this. And we have to understand that the wider the circle of people will be engaged in understanding the CSRV, it's doctors, legal professionals, medical professionals. So it's about legal law enforcement of primary level, district police officers who still are not educated on this, who are not engaged in this mechanism. So this kind of coordination is what helps all the survivors to get effective assessment and will show that this mechanism in the law is actually effective. And then, of course, the project of preliminary transitional reparations to start working on this mechanism, which will later be made into bylaws, so that we understand where it works, what kind of gaps, if any, we have, where do we have to strengthen this, and how we have to inform them, how to inform the society. And for me, it's also working with our donors and also with the state budget, money allocated for social rehabilitation of CSRV survivors, which grants the right for social restoration or social recovery. And that enables us to work on all stages with all the stakeholders. Thank you. I would say just pass this law, let it work. That's what you have to do. There are people who survived CSRV like 70 years, or in the 70s or in the 80s. Well, no, the people who are in their 70s and 80s in age, we need this law to start working, and that's what we need. I know that there are a lot of criticism, recommendations to this draft law. We have the European Commission, we have different ministries, different visions, ideas. We understand that. We understand that the law is not 100% perfect. But if we wait more and more and keep waiting and keep deliberating so that all the stakeholders agree, it can take incredible amounts of time. We have to find a compromise. We have to make it work. Well, some things maybe should be submitted for further discussion, but we have to pass it in the working shape. And then, because we understand that our pilot project to transitional reparation and other initiatives, we don't know how it's going to work. We don't know what's going to happen in a year with this war and et cetera, et cetera. So we need to have some framework now. So it doesn't mean that if we pass this draft law like this, it's going to stay like this forever. We can amend the laws. It's just normal. In other countries, I forgot which was it, but in some countries, the reparations law is just 2 pages, just general framework. And then the secondary law and bylaws provide additional provisions. And that's what I think regarding passing this draft law. Of course, it needs to be approved, amended, and properly constructed, but let's make it a general framework. Let's be really human-focused. Let's be survivor-focused. On my hand, it's maybe a lighter role at the moment because everybody said basically everything. But on the other hand, it's a difficult role. What should I say? And so I'm going to say that each of us who is engaged in resolving this issue, assisting the survivors through different means, we should do what we do wherever we are, learning and basing on best practices, doing what we can to actually help the CRSV survivors and continue providing complex multi-sectoral work. In our country, thankfully, we have all the systems, they all work. It's social services, it's healthcare, it's specialized services to support GBV survivors, the legal assistance, and law enforcement. We have these working agencies doing important work to continue this work, provide necessary training, train people, make them aware, make them nurture the culture of working towards assistance. And of course, we have the framework agreement of cooperation, which was signed 2 years ago, and we have implementation plan. And each of the owners of this, each of the representatives of government, organizations, civil society, international, other players, they know what to do. Each has a task, the deadline, and indicators. We just have to continue moving towards what we need.
And then we go to Natalia. Natalia, can you hear me?
I can hear you. Can you hear me?
Yes, please go ahead. But we are not seeing you. They will show you on the screen just in a second.
Okay. Okay. Well, I can start and then you can see me later. So I'm going to address how the international community in particular could support the implementation of the reparation mechanisms. Continuing on from my point earlier, to be effectively implemented, a reparation scheme requires resources, and some of these resources can be provided by other states in the international community. Members of the international community should identify funds, whether that's monetary judgments, fines, penalties, forfeiture orders, or other revenue that could be used to resource a reparation framework. For example, governments in the UK, the EU, and US are currently considering how frozen Russian assets in their jurisdictions could be confiscated and repurposed for the benefit of victims. Some existing routes linked to assets that have been criminally obtained are already available, and new legal bases for the confiscation of state and individual assets have been created and proposed in countries such as Canada or Estonia. In addition, practitioners are also exploring short-term alternative solutions to finance reparations for Ukraine, such as repurposing penalties imposed for sanction violations, introducing a windfall tax on the interest generated on frozen Russian assets, enforcing Ukrainian judgments in international or third country states, and voluntary donation mechanisms whereby sanctioned individuals can volunteer their assets for the benefit of victims of the conflict in Ukraine. In the UK, there's also a unique case involving Roman Abramovich's sale of Chelsea Football Club, which was permitted in May 2022, despite him being subject to UK sanctions. In accordance with Abramovich's pledge, the UK declared that the 2.5 billion proceeds of the sale would go to Ukraine through the creation of a charitable foundation. However, this process at the moment has reached a stalemate, with neither the UK government nor those tasked with setting up the foundation taking any responsibility to take this matter further. We understand this is due to disagreements over how the funds should be spent. Linked to this, it is of course important to emphasize that the exploration by the international community must be closely aligned with discussions surrounding the delivery of reparations. Despite there already being many domestic and internal mechanisms that have the potential to fairly and effectively distribute reparations, including the Ukraine Register for Damages or the ICC Trust Fund for Victims, it is striking that governments are still not actively considering challenging any confiscated or gathered funds into these mechanisms and support their coordination and effectiveness. And this brings me to my second and final point, of course, the need for coordination. There currently appears to be a lack of an overarching strategy and coordination among different actors on the domestic and international levels. This risks duplicating efforts as well as the re-traumatization of victims that may have to register their claims for multiple initiatives. To ensure the effective implementation of a reparation framework, national and international actors working in reparations for CRSV victims in Ukraine must cooperate and coordinate their activities. Governments within the international community in particular should consult the Ukrainian government, survivor groups and civil society, as well as other international actors involved in mechanisms for the delivery of reparations in Ukraine, to inform them of the efforts being made and to better understand how the funds they gather can be used to finance existing reparation mechanisms. I'll stop here, but I have to answer any questions.
Thank you so much, Natalia. Kateryna?
Так, і на продовження.
Yeah, to follow up, we would like to start Q&A, questions and answers. If you do have questions, please raise your hands. I see first hand, Galina, please. You will be approached with the microphone now. Thank you. I'm Hanna Zhukovska. I work in the apparatus as a governmental ombudsman. And it's probably not the question so much, but a comment to what I've heard in the big room and now. And I want to support two things that I've heard. First is from Marina, that we have to work right now. We don't have to wait till the law is passed, and that's what we're doing. But I would like to support what Vasily said, because we have a great experience of helping survivors of human trafficking. And I remember how we worked with that back in 2010. And we started, back then we didn't have the law yet, but we already started providing assistance to survivors of human trafficking. And of course, we had assistance from MOM, from OECE, and we also worked together on implementation and designing of our basic law. So what is the proposal? The proposal is that we already have experience of SEMA, which actually works and works quite effectively. And we have experience of Dr. Mukwege. We have a representative of Dr. Mukwege. I would start with international standards of achieving of granting assistance. There is experience, there's international standards, let's bring them all together. And then we should approve the standards. Julia says that her family needs assistance all the time, and we know about this. And that's what it should make it different from survivors of human trafficking. The experience of Bosnia and Herzegovina, Croatia tells us that these people have to receive assistance all the time. And we have to start moving now. When we see those standards, we have to see stakeholders that we engaged in assisting, and that's going to help us even now in advocacy, because we will have real needs, financial needs. We already have them, and we have to deliver our mission in helping the survivors. Thank you. Do you have any more questions? I'm from Kherson, Survivor Assistance Center. Well, first of all, it's a proposal from me personally, as a survivor. We need to simplify the process of interview. First is an interview which is recorded by an investigator. Then it is another interview on camera with the presence of psychologists. and a lawyer. This is really re-traumatizing for the survivors. It's severe re-traumatization, and it should be gotten rid of. Second proposal is what I faced in my work already. There's no rooms for proctology, for urology for men. There are gynecological rooms for women, but there are none for men. They're still left behind in that. I don't know how in other cities, but I'm saying it about Kherson and Kherson region, which is deoccupied. Just as well, we would like to see more mobile brigades, because they still don't work everywhere. There are elderly people who also survivors, and they don't want to talk about it. But through some time they agree, but they want this to be outside of their own village or residential area. They want this process to take place elsewhere. For them, more secretly, so to say, more sensitively to their privacy. Right, so it's about responding and identifying the people who suffered and survived this. So it's about services, and it is committed against all people, and there should be an awareness campaign so that people are capable of identifying themselves as survivors, and services are made available for them. So when we talk about pilot project and reparations and the draft law drafted by Madam Barden, and it's very different from criminal proceedings. We don't have testimony for camera. We don't have interrogation. The idea that we don't persecute the culprits, and the fact that we open the opportunity for the survivors to speak as much as they want. That's from my experience. As Christian said, an example where he was the legal secretary of the Truth Committee in Chile. 20,000 suffer from tortures. And he said that even when the person begins to talk, they still stop. And you see that that's where traumatization is. So you have to trust that person. Our project and the whole idea of the so-called administrative reparations, I call it like that because there's a huge confusion between reparations as in society and reparations we talk about now. It's very important to have principle of integrity. There's no interrogation. We don't prove everything. We corroborate the fact that the person states in order to provide compensation for them. It's the standards that Halina said. I agree that there's international standards, but they have to be adapted to Ukrainian context. And there are many of these standards that don't work in our context. They're not applicable. And I would say that we're designing now something new from scratch, capitalizing on some philosophy of standards programs, the Panzi model from Dr. Mukay in Congo, and they work differently in different countries. So we need to adapt everything. Don't take and copy-paste everything. Copy-pasting doesn't work. So I want to comment the comment of the assistance to the Shunevych Center. We need the case management in Ukraine. The case management is basically the safeguard that the person who comes to a service for assistance really receives that assistance. That the case manager that knows all the players can talk to a person in a sensitive manner, gauging their needs, offering the plan of actions, accompanying them on different stages, and then to monitor how that person receives those necessary services. And I think it's very useful and very good that this network of survivor center assistance includes 11 centers. It's a network, plus there are mobile services. So mobile brigades, psychosocial assistance, medical mobile brigades, and we can agree that at some in some residential area in Kherson, at some point a mobile brigade comes over, and there are people providing services to people who maybe are fearful of condemnation among their community, but for them to enjoy high quality services, and also referral cards. They are already designed. There are projects to make certain communities free from domestic violence, and over 40 cities and towns that they have referral cards for that list different services. And also these referral maps for each region in Ukraine. You just check this map and see which services are available. Legal, law enforcement, civil society that they are eligible to. I support the idea of case management because right now, the Ministry of Social Policy, we're already completing the case management system for all social workers, and that's going to be a unified system. There will be protocols, and there will be tools where we can see because if we see that the service is not a good quality, we engage into the social sphere all that have to do.
You, please.
В мене є
I have a question. Do you plan that the affected person or survivor can submit their data through electronic means? Because even in case manager, even if it's a mobile brigade or experts coming over locally, whenever it raises attention, for the experts to come and make a session, people get together, and when people get together, that means they will hear the information that this person suffered that and survived this, so they will for sure know the whole story. That's the first thing. So it's a risk of unnecessary disclosure or exposure. Second risk that we're running in this is that we're saying that there should be a complex psychological system. 100% so, and it's gonna last for years. It's not just one ad hoc meeting. It's not even a month or 6 months. The standard will have in itself some limitations. It's a year, and after that longer, but it should be accounted for. We keep hearing that it's not for a year or two, it should be for longer. So it's different options how we can get out of traumatic experience. And as well as experts. If we understand that it's a certain standard, certain assistance, then it's a social sphere. Someone is reporting, the law enforcement cooperation, the way we counter human trafficking. So that means that there is an owner, there's a responsible person. It's not always psychologists. Yeah, psychologists are sensitive to the problems of survivors. They are well trained, but they are still not psychologists. Do you foresee, which is part of the challenges, I think, a psychologist so it's a social departments, so it should be psychologists. So they refer the intake, So psychologists who would be able to do some basic casework. So I can start with from the last. When we talk about case manager, it's not just some cold, reasonable person, but in Federer McQuaid we have psychosocial assistant. In the Ponzi model, there's case manager, but they don't call them, say, case manager, say, Maman Chérie, or dear mother. So it's a person that accompanies the survivor. It's exclusively CRSV or other traumatized through torture, etc. So we hope that this pilot project will be effective and it can be scaled up, and later as national service consulting people. So the idea of accompanying those people is important, and it's and how to file online applications. So just imagine you are a survivor, you are a CSRV survivor, and you see this form, and you have to find which form of sexual violence you actually survived. Well, how do you determine that? You know, right now in the pilot project, there will be people who already identified. It's one person who comes to the village, and they can change their clothes not to be too different, not to stand out too much. So we can discuss that, how different forms of communication should be, online, offline. But my colleagues believe that online is very cold. It doesn't carry trauma-oriented approach. Even if you do everything possible through online, you don't expect people to come clean, to speak their mind. Yeah, it should be a sensitive form. It should be a proper form. But when we do info campaign, awareness raising campaign regarding CSRV, we talk about different types of exploitation. We post it on big board and booklets. Our idea is for the person to self-identify as a survivor. We understand that it's difficult for them to open up, and my personal conviction is that until a person identifies themselves as someone who needs assistance, they will not open up to others. Or it's very rare that they will open up and say, I'm from such and such region, we were under occupation, and we know that not in my city, but there are some districts that were occupied, and we know for sure that there are survivors there. More so, people themselves, the activists and those we implement projects to identify the survivors, but it doesn't work so much. For at the moment they need information for them to identify. If they read it, if they understand what kind of assistance they can receive, and only then it can work. And it's an online form that works when they self-identify. Because when they come over and tell, we aim our info campaigns at telling people what types of CSRV for them to recognize that this is their story or this is not their story, and that I think can work as an so there should be different options. That's what I mean. Right. I want to comment as well, because in our draft law, there is this opportunity for responding for the survivor to share their data, not through vis-a-vis communication, but through survey, through electronic survey, where there can be additional questions posted through online. So that's the mechanism. We never know in advance how well it works, but there are other countries where it did work. I may be wrong in some numbers, but it's about 1,900 applications they received, and 1,200 were really corroborated. Indeed, that's the survivors. Others, of course, were some frauds who wanted to get some free money from the state, but they were filtered out. So and it works. So I think that, quite on the contrary, the draft law should be passed into action as quick as possible. It's going to be a basic framework. We were talking so much and we were learning so much from experience of other survivors. We say that there will be no new model. More or less, it's going to be the same thing. It just has to start working. And I'm going to say that in draft law, we were writing so many different nuances so that it doesn't come to distortions. Like we pass the framework, the general framework, and then everybody turns this framework whichever way they want to interpret. Also, we talked about case management. It's important, but just on this last weekend, I was talking to Mariana Mamonova. I think you know her. This is it's our military medic who was in captive, who was exchanged as she was in the 9th pregnancy month. So she says, I came to study as a psychologist now, because other than us ourselves, the ladies who were in captivity will not be able to help ourselves. I work with different psychology, but no psychology has communicated with me correctly what I wanted to hear from her. She says, when there was a person sitting before me who's never been in captivity, who is not a woman, and says, I understand you, I don't trust that understanding. So I think the state has to support such survivors as Mariana. So some training that they can receive, how to build that project, because the person has some ideas, but she's not a project manager. She's a survivor, and she may not know how from the get-go. So which donors to address to, what are the colleagues who will help her, with whom she can build trusty relationship. So I think this is what we should think about, where we help and support these children ourselves. I thank you for the courage that you display when you talk about it. I can only guess how high is the level of your traumatization, but what you say helps us, and it helps women and girls who went through similar experience. Hello, I'm Lilia Leonidova from Odessa. Regarding chatbot, let me tell you that yes, there is such resource and it's being used. It's a joint project of La Strada and Prosecutor General. And I know from our experience in Odessa that we already filled out this chatbot. The survivors who right now, 2 weeks ago, we recorded. 2 weeks ago, they decided to start talking. So we have this resource. We think it's safe enough. And yeah, we can work with that. We can really inform people. I also wanted to express this proposal. Regarding the use of practices, the best practices that already exist in Ukraine, just recently Galina mentioned this procedure, how they register survivors of human trafficking. It's so great, it works. Of course we need some new approaches, new concepts, but we need assistance here and now. As for our colleague from Kherson who represents the Survivor Assistance Center, survey. In Ukraine there's already good enough service, which is a survey of children who survived sexual violence, so-called green rooms, Barnahusek or whatever they called, but we also work with that format. We know that if a survey is done by experienced psychologists, we are indeed understaffed so much, and psychologists that we have, we got to train them. And it's a great idea to have psychologist sessions between equals. But when the psychologist first surveys, queries the survivor, especially when it's a talk between two survivors, this may cut many unnecessary stages like investigation, etc. So it should be reflected in the law, because without the law we won't be able to to work in that format. Thank you. In Kherson, unfortunately, no, there are no green rooms. Right, thank you. So it's about accessibility, but to follow up this opportunity, let me tell one short question. We talk about justice a lot. And when we talk about justice, we talk about truth. Truth is also about courage to see what we're good at and to honestly see what we're not good at. So if you've seen any successful experience before the draft law, after draft law, we talk about international practices, but maybe we already have that. And secondly, where else we should work on? What else we should work on to make the service available? So, successful experience. I'm very critical in terms of success. You know, successful experience, we do have some organizations, smaller, bigger, they already provide assistance. We have organization Blue Bird, Natalia is from here. So there is successful experience. There are people who were, before they were doing something completely different. It's just, it had to do with helping survivors. They start working, they start providing assistance, they fundraise money, it takes a lot of emotions, a lot of effort, but it's a successful experience when people start helping other people and they do it better than, unfortunately we have to honestly say, our national structures locally. So central approaches is usually well-centered approach. But when we look at the local level, Kherson region, investigators, etc., we know that there is no human-centered approach there. I remember we talked with Irina Dudenko. I said, what kind of training you need? And she said, we need to train 2 million people, experts, trauma-aware, trauma-conscious assistant. So we need to we need to inform people about trauma-centered approaches, both investigators, medical professionals who provide first aid. So how to do it in practice, I don't know. I know that there are a lot of efforts being used, and then the National Service does a lot of training. So we need to increase that capacity so that people locally understand that they have to account for trauma of another person whenever they work with that person. Yeah, I want to support this, what you said just now about the training, because indeed what I face a lot in my work, this lack of culture in society, and I call it culture. All of us, we have the same worldview about the same problem or task. And I just remember years where domestic violence and gender-based violence was a closed topic when we talked about this type of crime. And now in the parliament there's this discussion about sexual harassment. It's a new page where you have to prove or explain the colleagues that this is something completely new for them in terms of law, in terms of legal framework. And as for CRSV, so, you know, we need to spend so much effort to establish this culture, because despite the fact that the war is going on for more than a decade, still a lot of people don't understand what it is, because there are people affected from previous year. So that's why it's important to work on this culture. And it can also go through training of experts, of specialists to work with this. From the positive experience, the draft law that we have right now, it already learned from other countries. I talked to my Croatian colleagues who basically, they wrote this draft law 15 years after the war was over. for 15 years it was not regulated. So there are countries like that, and we can learn from them. We absolutely have no right to lose, to waste time without our people getting assistance. So we need to, so that's why we get into coalition to support these changes and to really help and assist the survivors.
Just also to share some views from the international perspective, listening to what you are saying. So starting with the urgency to act now, I just want to say in Ukraine, we are having a unique opportunity to pass a law that might not be perfect, but is the best I've seen worldwide, trying to put an urgent program of reparation in place. And I just want to invite you to look at the decision, the ongoing decision decided by the International Criminal Court last week, where it recognizes the need to also have urgency on reparation. So this speaks directly to what you are doing here now. This is the ICC. And the ICC has said we need to give a symbolic award of 750 euros to the victims, but we need to prioritize across 52,000 victims in the case. 52,000, not potentially 4,000 or 7,000 like here for conflict-related sexual violence, but 52,000 victims. And the ones that need to go first across the groups is the groups where the most urgent harm is at stake, where the threat to life is at stake. And this speaks to victims of conflict-related sexual violence. So you are not outside the paradigm, you are completely showing where we need to go. So I think that is absolutely crucial to support this effort, because this is also an interim effort. This is not the full reparation, no, it's just an element of it. And it's a unique opportunity to respond in real time to victims. But the other point that I think was crucial here, Fedi, you mentioned it, is that what we've learned from international practice is that laws that have been enacted to provide reparation, including to survivors of conflict-related sexual violence, have been amended once and again, because we are learning by doing, because we need to adjust, because there is no one approach that fits one context. We need to really try and see what is really survivor-centered. So we will have bylaws, we will have many opportunities to improve the framework and to really respond to survivors' needs. And the final point I wanted to make is on the children. Julia, it's so crucial what you are saying. And again, just to go back to not only to Ms. Bardina's draft law that includes children and children born of war both, but also to the ongoing case, the court recognized last week in much clearer terms that the Taganda case, that there is transgenerational harm. That when a child suffers as a result of the impact and the harm suffered by those that have brought him, her, or them to life, there is a harm to be repaired too. No? So I think we need to really move in that direction. It's not only the survivor, but the children could also be strongly impacted by conflict-related sexual violence.
І ще на завершення або в продовження цієї розмови.
Also, to follow up on this, let me remind you that we already mentioned implementation plan that we have to the framework agreement between government of Ukraine and the UN system to prevent CRSV. So you have QR code in your folders, and you can see what the state does, including providing the urgent reparations as of now, already done, and the main priorities that we mentioned is determining the status, passing the law, and passing many secondary laws. That will be the priority for the nearest future. And implementing the system of urgent interim reparations, that's what will help everybody who already spoke of their experience, and those who are still not ready to come to the state and say openly, I need assistance because of that and that. I hope soon we'll be able to provide these effective approaches and mechanisms where each person will feel safe and protected, despite the security risks that we have right now. Remember, we're still in large-scale invasion, and it's still not over.
Looking at the room and who we have here on this panel, it's quite interesting, no? Because we have an urgent interim reparation program starting for 500 survivors that is going to provide very interesting practice, while the Bardina law potentially is approved by Parliament, and that will be able, in an ideal world, to bring that to the next level, for then the Ministry of Social Policy to take action and lead on also the development of further reparation, not only for survivors, but for other victims, so that we can respond to people like you, Julia. And we wouldn't be able to do that without persons like Olga, who are really working with the survivor centers, etc., to facilitate assistance while the reparation element kicks in. So I think it's very special to see this panel we have here, because it's that action, multi-stakeholder approach, the one that is going to really deliver for survivors.
We have one more hand. Let's thank you for this. Koltunova Kateryna, Deputy Head of Kirovograd Regional Military Administration. This is incredible to see that all in the same context, they're working together and creating this whole system together. But let me point out that implementing these great tools, this great system, whenever we go deeper in communities, we have a different situation in terms of expert availability, people providing services, etc., etc. So in context of conflict-related sexual violence, we maybe not need such a wide network of experts, like 60 psychologists for one region and all of them super qualified, because that's not realistic. It's not realistic to glimpse in everybody's soul and to press quickly that button that will make the will create the remedy. We're building the system of psychological assistance, the system of veteran centers in our region. We see how many things determine that's what we did, that's what we created, that's what we made instrumental. And then if that person is, so one person in the wrong position can really damage everything that we worked on previously. Question about the active military who return from captivity. Do we have the algorithm of working with them on CSRV survivors, or do we not put them into separate category? Because whenever our military return from captivity, they go through rehabilitation. I can imagine that on the rehabilitation stage, they should receive all that information. When they get to community, in the community they shut down, they never contact. So do we put them in a separate category? What's the algorithm of working with them? Is it mentioned in the law? And I also thank Clara for saying, talking about children who were born out of CSRV or are survivors who suffered from these crimes. There will be a separate provision about children who suffer from military conflict with a separate status, and it has to be synchronized so that later in 5 to 7 years we don't need to clean up or patch up something that we forgot. So we should synchronize these two processes so that they are in the same context. So it's just a practical vision. In fact, systemic work to build and develop systems for helping CSRV survivors, GBV survivors. So there are great people who are capable of implementing these things as Barnahus, Green Room. We need to quickly work on that to later build upon it on practice. So and also the military who return from captivity. I'll respond quickly. In the draft law, there is a category of children born out of CSRV, and children who became witnesses or who witnessed such crimes, and they are also among the affected category. As for the shelters for CRSV survivors, there are mechanisms that work. but I've seen some very heavy experience. So we also learn to work with the shelters, and at some point there is enthusiasm, and some people don't know at all. I've seen a shelter where in a small town they just had a small room and some microphones. So it's about culture and awareness. For the military, our draft law does not replace the mechanism that exists right now, where you can work through courts. But we are creating this unified mechanism. The opportunity for a survivor to come to a specific institution that is sensitive, and there is a committee that gives them a written certificate, and that enables them to be eligible for assistance. That's a preliminary reparation. So the military, our pilot project does not cover the military because we have too little money on the first phase. There is a need to have separate protocols of working with the military. We see that there is a need that the military leadership that is responsible for rehabilitation of the military, and because we have the National Guard, we have the Armed Forces of Ukraine, that's who needs to get engaged to design proper guidelines. And you know, there are no such specific protocols at the moment, but in our context they are necessary. It's a similar context in Syria. We have so many captive men who suffer from tortures, including sexual related crimes. So a lot has to be done. Microphone. Natalia Melnik from Bluebird Civil Society Organization. I want to say that the very fact that I would not put separately like CSRV for the military. So the consequences are the same for the military and the civilian, and the assistance should also be the same. But I would like to get back to our first comment from Julia, which she says that they have a so we work since 2015. There should not be limitations for psychological assistance for the survivors of GBV and CSRV. We don't do limitation because people who don't need that assistance, they don't come for it. So humanitarian assistance or some monetary assistance or other assistance. So psychological assistance is different. It's spending your time with that. It's not that people who don't want it will come for it. No, they just don't. Nobody needs that because that doesn't automatically like give them money or something. So in our experience, we have some cases where for years psychologists work, but that doesn't mean that they have 500 consultancy sessions each week. No, they do some break, the recess, and then they come back. They don't allow burnout. But at least if it's your psychologist, you trust that person. You know that you're not on conveyor belt. You know they really work with you. And the best result of recovery is when we can work with the survivor and their family members. Right, and it's about training, as we said. It's also a plea that we all in the state has to work towards that, and I know that you're already working. High quality, qualified assistance. And if we talk about training, it's important to understand that this training should not be just one-off, and it should be a systemic approach. So it's a system that we anticipate high quality services that are really survivor oriented. So let's continue the discussion during the lunch break. We thank the speakers for your work.